Hello everyone, and welcome to a special episode of my PIP Monthly. Today we will be talking about the Andary decision that was just recently issued on August 25th, 2022. So we thought it would be a good idea to come to you guys with some breaking news and kind of unpack this decision for our listeners. And of course, my name is Amber Rouse Holloway. Please feel free to contact me if you guys have any questions about the material we're going to talk about today. So as we all know, this Andary decision recently came out from the Court of Appeals on August 25th, 2022, and is for publication. Essentially, as we all know, the Court of Appeals held that the 2019 amendments to the Michigan No-Fault Act do not apply retroactively to claims arising from accidents which occurred prior to June 11, 2019. Per the holding in Andary, if an individual sustained an injury in a motor vehicle accident before reform, that MCL 500-31577 and MCL 500-315-710 may not be applied to limit such an individual's no-fault benefits. I'll also go into greater detail discussing these specific sections of the No-Fault Act. Essentially, they center around the no-fault fee schedules and provider fee schedules. So as we all know, 2019 PA 21 and 2019 PA 22 amended the No-Fault Act to include fee schedules, limiting a provider's reimbursement amount. Andary specifically concerns Section 7, which caps a provider's reimbursement for services not covered by Medicare. It caps them at approximately 55% of the fees charged as of January 1st, 2019. Also at issue in the Andary decision is Section 10, which limits the reimbursable hours of family-provided attendant care to 56 hours per week. The big question in Andary is whether the amendments, the June 11, 2019 No-Fault Reform Amendments, apply retroactively to accidents that occurred before the reform took place, so prior to June 11, 2019. I did want to give you guys some background into the Andary case. So in October of 2019, the guardians of Ellen Andary and Philip Kruger, along with the Eisenhower Center, filed a 18-count lawsuit in Ingham County Circuit Court. I do have the site listed for the court case. This case sought a declaration that certain amendments to the Michigan No-Fault Act were unconstitutional. Specifically, Andary discusses that MCL 500-3157 Section 7 and Section 10 were unconstitutional. And under these amendments, specifically number 7, it caps the medical provider's reimbursement to those not covered by Medicare to 55%, and also Section 10 limits benefits for family-provided attendant care, and it limits those benefits to 56 hours per week. So here we have two plaintiffs, both Andary and Kruger, who were permanently disabled as a result of accidents that took place prior to the reform. Andary requires 24-hour care, in-home attendant care, and all of this care is provided, or the majority of the care was provided by her family members. And Kruger is a patient at the Eisenhower Center, who is also a plaintiff to this lawsuit, which the Eisenhower Center provides inpatient living accommodations and rehabilitation services for individuals with traumatic injuries. Traumatic brain injury specifically. Most of the services performed by Eisenhower are not compensable under Medicare, which is why they felt that they were an interested party to this lawsuit. And the defendants in Andary were the insurers responsible for paying for and providing the no-fault benefits to both Andary and Kruger. At the time of the accidents, Andary was covered under a PIP policy issued by USAA, and Kruger was covered under a PIP policy issued by Citizens. Now, prior to the Court of Appeals action, in the trial court, the plaintiffs here asserted that they sustained injuries prior to no-fault reform, and therefore they were not subject to the new limitations on benefits. So no cap to 55% of treatment that wasn't covered by Medicare, and no attendant care cap. The plaintiffs argued that they had a vested contractual right under the policy in effect when they were injured, and that the payment limitations of no-fault reform violated the contract's clause of the Michigan Constitution and thus violated their constitutional rights to equal protection and due process. Now, after this lawsuit was filed, in lieu of filing an answer, both USAA and defendant citizens filed a motion for summary disposition pursuant to 2.116C8, and they argued that regardless of when the plaintiff's injuries occurred, they are subject to the newly enacted limitations of MCL 500-3157, and that such application does not violate the contract clause or any other constitutional provision. The trial court did agree with the defendants and granted summary disposition to both USAA and citizens. And there we have the appeal. Now, on appeal, the Michigan Court of Appeals faced three issues. One, whether the legislator intended for the No Fault Act Section 7 and Section 10 to apply retroactively to those injured before reform. And two, if retroactivity was intended, whether the retroactive application violates the contract clause of the Michigan Constitution. And three, whether application of MCL 500-3157 Section 7 and Section 10 to past, present, and future victims of motor vehicle accidents would violate the victim's due process and equal protection rights. So, one, whether it applies retroactively. Two, if it was supposed to be applied retroactively, whether the retroactive application violates the contract clause. And three, whether it violates the victim's constitutional rights, specifically due process and equal protection. Now, with the issue of retroactivity, the Court of Appeals held that amendments may not be applied retroactively to persons injured in accidents that occurred before the amendments were enacted. Generally, statutes and their amendments are presumed to apply prospectively, so for future cases, unless there's legislative intent that the retroactive application was necessary. Again, to overcome the presumption of prospective action, the legislator must clearly manifest an intent for retroactive application. So they must clearly identify it. It must be clear, direct, and unequivocal, the intent to retroactive apply these amendments. Ultimately, the court did find that there was no legislative intent for the amendments to apply retroactively, but the court did also look into other sections of the amendment of the No Fault Act and found that ultimately there were no unequivocal expression of intent for retroactively. The court also placed significant emphasis on the plaintiff's settled rights and expectations prior to the amendments. According to the court, retroactive application here would alter the injured plaintiff's settled rights and expectations under the pre-amendment No Fault Act. These were obtained in exchange for premiums based on defendant's obligation to pay all reasonable charges not subject to fee schedules or caps. The court took into account the number of catastrophically injured individuals that would be affected by retroactive application as well. Next up, the court had to discuss the issue of the contracts clause and whether, if it is held that the amendments were retroactive, does retroactive application violate the contract clause of our Constitution here in Michigan? The court noted that the purpose of the contract clause is to protect bargains reached by parties by prohibiting states from enacting laws that interfere with pre-existing contractual agreements. The court cited the case of Gary v. State of Michigan, and here the court presented the following three-part balancing test, which was used to determine if the contract clause had been violated. So one, whether a change in state law had resulted in a substantial impairment of a contractual relationship. Two, whether the legislative disruption of contract expectancies is necessary to the public good. And three, whether means chosen by the legislator to address the public needs are reasonable. Ultimately, we know that the court held that retroactivity of the amendment would violate the Michigan Constitution as to the contract clause. Now, on to the due process and equal protection argument. The court decided to not really discuss this issue. They explained that with respect to the plaintiffs, Their ability to obtain full PIP benefits renders them without a distinct and palpable interest in the amendment's future application. As a result, the courts dismissed the plaintiff's claims that prospective application would violate their constitutional rights. However, as to the provider plaintiff Eisenhower, and no-fault insureds injured after the effective date of the amendments, the court held that those parties did have a distinct and palpable injury, and the court remanded that specific issue to the trial court for discovery necessary to determine whether the reform did affect their past constitutional rights. Did affect their constitutional rights. So with respect to retroactivity, the court ultimately held that the amendments may not be applied retroactively. And 2, with respect to the contracts clause, retroactivity would violate the constitutional rights of the plaintiffs with regard to the contract clause of the Michigan Constitution. And 3, the court decided not to resolve the issue of if it violated their constitutional rights regarding due process and equal protection. So here we have the question as whether the legislative amendments to the No-Fault Act apply retroactively, and the answer is a big no according to our Court of Appeals. Ultimately, the big takeaways are that the Court of Appeals decided that the legislator did not clearly demonstrate any intent for the amendments to apply retroactively, and further, even if it was retroactive, imposing the new limits would substantially impair no-fault insurance contracts entered into before the amendments, thus violating the contract clause of the Michigan Constitution. And like I said, with regard to the constitutional issues of due process and equal protection, the courts declined to resolve that issue with respect to plaintiffs Andary and Kruger. I did want to briefly talk about the Judge Markey dissent. The dissent centered around Judge Markey's conclusion that the legislative changes made to MCL 500-3157 apply to automobile accidents that occurred before no-fault reform. The dissent highlighted MCL 500-211F, Section 8, and said that that section read in conjunction with MCL 500-3157 made it clear that the legislator intended that the reform be applied to accidents and injuries arising before June 11, 2019. The judge indicated that MCL 500-2111F, Section 8, expressly references and effectively incorporates MCL 500-3157, and both statutes were encompassed by the 2019 legislative amendment or no-fault reform. MCL 500-2111F8 mandates that insurers pass on savings realized from the application of the No-Fault Act to motor vehicle accidents at issue in this specific litigation. So even if no savings are realized, it doesn't change the fact that the legislator's indication and its intention that no-fault reform be applied to accidents occurring before June 11, 2019. And of course, this is Judge Markey's opinion in her dissent, but that's how she came to the conclusion that she believes that the amendments do apply retroactively, because taken in combination, these two statutes incorporate and reference no-fault reform and the amendments that took place on June 11, 2019. She also discussed the issue of the constitutional violation regarding the contract clause. She indicated that, or highlighted that, both defendants argued that there were no contracts between the parties, considering that both Andary and Kruger were not named insured under the policies at issue, and that Plaintiff Eisenhower obviously had no contractual relationship whatsoever with either defendants. The majority here, according to Judge Markey, simply ignored this argument and moves directly to the issue of whether the no-fault amendments substantially impaired the obligations under the contracts of insurance. But here, Judge Markey is saying that there were no contracts between the plaintiffs, all three plaintiffs, so plaintiffs Andary, plaintiffs Kruger, and plaintiffs Eisenhower. There were no contracts between them and the defendants because they were not the named insured and one was a facility. She also indicated that even if there was a contract and a contractual relationship existed, defendants USAA and Citizens did next maintain that the rights to certain level of PIP benefits are not contractual rights but are instead statutory rights, thereby incompatible with the arguments under the contract clause or the Michigan Constitution. And the majority here in the Andary decision addresses that issue as a part of its retroactive analysis. Now, with all of this being said, talking about the opinion and the dissent, we still have the issue that the Michigan Supreme Court does have the final say. There may be appeals on this issue, and these appeals may take more than a year to resolve, and we just have to wait and see how this issue or this decision plays out in the Michigan Supreme Court as well. And there we have it for the breaking news episode of the Andary decision. Please feel free to contact me with any questions and or concerns you may have. My name is Amber Rouse Holloway, and thank you for listening.